It's critical, because of the angle that the police officer, I watched him pull the sack out of my pocket, my personal Native American herb, and then he shoved it back in and took me to jail with it. I watched this. My friend watched it. He got video of it. I'd like to see the other 10 cops that came there with their guns out. Again, under intrinsic versus pecularo, anything that the prosecutor says and puts on the record is to be struck. Attorneys cannot give testimony or be a witness in a court case, and I do believe that has happened here too. So we have mass violations of the Constitution and the laws of the United States. And I'm going to need to see your foreign agent registration supplements and your filings with the Attorney General of the United States. I gave you the judicial notice, and no one, not the clerk, not the judge, not the prosecutor, not the false impersonating prosecutor, has showed me a shred of anything. This is false impersonation of a government actor under 18 U.S.C. 912.
So check this out, because today we're in a Michigan district courtroom where Robert Sigsby, no lawyer, just himself, is demanding body cam footage from the 10 officers who showed up guns drawn over a seatbelt stop, claiming one of them pulled something from his pocket, put it back, and still arrested him for it. He's here for a follow-up because the judge already ordered that footage turned over last time, and it never happened. Having to repeat a court order is already a problem, and that tension sets the tone for everything that follows.
All right, Mr. Sigsby, you're up. 25T01947FY, people of the state of Michigan versus Robert Wayne Sigsby. And Attorney Bagrakis, you'd like to place your appearance on the record?
Bagrakis on behalf of the people.
And Mr. Sigsby, can you state your name, please?
My name is Robert Sigsby.
Okay. All right, we are here today on this matter. We're back on an adjourned PCC. We've had a couple of PCCs at this point. The reason for the adjournment today was to ensure we were going to check on the exchanging of discovery. We were here on August 14th, and Mr. Sigsby has stated that he still needed some discovery. He wanted body cameras of all police officers present at the time of his arrest. And I did order any available body cameras to be turned over to Mr. Sigsby. So we have a probable cause conference on September 11th as well, because I wanted to give Mr. Sigsby an opportunity to, file any valid motions that he may want to file prior to exam after receiving all of his discovery. But we set today to make sure that there weren't any issues in regards to discovery. So, having said that, Attorney Bagrakis, what information do you have for me?
If this case already has you hooked, you're in the right place. Like and subscribe to Court with Mia. I cover the most epic, jaw-dropping court cases you won't believe are real.
Well, I know my recollection was that initially all the body cam videos were sent to Mr. Hilliker, and I believe he provided them. He indicated that he had provided them to Mr. Sigsby via a thumb drive. My recollection was also I see we have some cruiser cams, which I had directed my paralegal to send to Mr. Sigsby because, of course, as the court remembers, Mr. Hilliker was removed from representation. So now we have to deal with directly to Mr. Sigsby. And there are, to my knowledge, I don't see nor have any other body cams that are available. We've given or will be able to provide him what we already have.
So here's where it gets a little frustrating to watch. Attorney Bagrakis from the prosecutor's office shows up and basically explains that the reason discovery wasn't handed over is because nobody was physically in court that day. In the judge's response, she points out that her order was made in person, with everyone present, and the date was set specifically so this exchange could happen face-to-face. No confusion, no miscommunication, just an order that wasn't followed. Bagrakis tries to be diplomatic about it, but the judge isn't having it. She makes clear that when she gives an order, it's not optional based on convenience. What's interesting here is that she doesn't blow up. She stays calm, and somehow that makes it hit harder, because you can tell she's had this conversation before, and she's tired of it. But that wasn't the whole story.
It's critical, because of the angle that the police officer, I watched him pull the sack out of my pocket, my personal Native American herb, and then he shoved it back in and took me to jail with it. I watched this. My friend watched it. He got video of it. I'd like to see the other 10 cops that came there with their guns out.
But the issue is just getting.
I can meet you. I want to confer with the prosecutor. I got a right to do that. So I was wanting to meet.
I'm not. There's nothing really to confer about, sir. I would recommend against. I would recommend against that, and I will judge. I will do what I can if the court will indulge us another adjournment. I will make sure that I at least look into the other, making sure that we have whatever copies of either cruiser cam or body cam we have available, that we will get it copied. And if the court tells me to show up at a certain place and time, I will be there, or I will have a representative there to hand deliver it to Mr. Sigsby.
So, Mr. Sigsby, if the remaining videos were put on a flash drive, you can use that?
I can use that.
Okay. So here's what I'm going to order today.
After the back and forth about discovery, logistics finally settles. The judge lays out a clear, no excuses plan. Any outstanding footage, cruiser cams, body cams, whatever the prosecutor's office has, goes onto a flash drive. Sigsby picks it up in person at the district court on Friday, September 5th, 2025 at 11 a.m. That's the order. She then turns to the probable cause conference date and moves it from September 11th to September 18th. Giving Sigsby extra time to review the footage and prepare any motions. He asked for more time, she gave it, and honestly, that feels fair. The discovery delays weren't his fault, so penalizing him with a tight deadline would have been wrong. What she does here is quiet but important. She protects the process without making a scene about it, and you have to respect that.
So, go ahead. What did you want to say?
It's kind of crunchy amount of time to watch the videos. I'm going to do it.
Yeah.
So, there was like 3 jurisdictions there, plus the sergeant was there. So he was close. You would think the sergeant of the sheriff's department would have his body camera on. And then there was at least 2 Burton cars. I do believe there was around 4 Burton police there. And I mean, if they're running out here, it looked like I robbed a bank is what it looked like. And there's that many people with their police, with their guns. And I couldn't understand this over a traffic stop, a civil infraction. The seatbelt is not an arrestable offense. He had no reason to ask him my ID. So Colder versus Law says I don't have to produce an ID.
All right, we're not getting into those things, but I do want you to relay that information of the people that you thought were there, so that Attorney McGregor.
Yes, and the Flint Township was there also.
Okay. All
so
right,
one of these people should have the angle of the police taking it out and putting it back in my pocket. That's suspicious of a crime in my mind for any cop to lay you out like that. It's that big of a bag. How could you not find it in a pat down?
Okay, and so last thing is the probable cause conference that we set to actually move the case forward was for September 11th, 2025, 11 o'clock a.m. We can leave it on that date, or we can put it a week after that on the 18th if you think you'll need more time, Mr. Sigsby. It does not.
Time is precious. I'd like to have more time. It would be nice for me.
Right. Okay. Attorney McGregor, are you opposed to putting the next PCC on September 18th?
I am not opposed to that.
Okay. All right, good. Okay, so then
Judge, may I inquire just one thing? Did Mr. Hilliker, did Mr. Sigsby receive from Mr. Hilliker the discovery that we already sent to him?
Yes. Right?
Yes. And there was a flaw in it. And I remember
I'm not getting into a discussion about what there is or isn't. What I want to know is, did you receive it from Mr. Hilliker so we don't have to duplicate efforts?
You're right. We don't need to duplicate the arresting officer's body cam because it's worthless the way he leaned on me that day.
Okay.
Well,
we don't need that right now, but you do have, I remember we talked about that. You do have that discovery.
Yes, I do.
Okay. So one more time. This is what my notes state. This is what we're doing. We're going to put any outstanding discovery on a flash drive, and that will be available for pickup by Mr. Sigsby at District Court on September 5th, Friday, September 5th, 2025 at 11 o'clock a.m. That is an order of the court that needs to be done. Probable cause conference will be moved to, and I will find good cause for that because of these discovery issues. Probable cause conference will be moved to September 18th, 2025, 11 o'clock a.m.
All right. Thank you.
I never
All right, thank you. All right, and then that's all of our PCCs today. I believe Attorney McGrath, do you agree?
Yes, I believe we've taken care of all of them, Judge.
All right, very good. Then have a good day.
Have a great weekend.
Yes, you too.
All right. Bye-bye.
We can write you out a notice if you want one.
Yeah, some on paper, because I got enough things going on in my own life. You know how that goes.
I understand. All right, very good. We'll see you on the 18th.
Get this from her right now.
Get it from clerk's office. So.
Clerk's office.
Yep.
In a few minutes. Thank you.
All right, you're welcome.
I know. You need a second to process that. Take a breath, hit subscribe, and let's keep going because it only gets better from here. Here's where things get interesting, because Robert Sigsby is back in a Michigan courtroom, and this time the charges are way more serious than a seatbelt. We're talking assaulting a police officer, bringing contraband into a prison, and driving with a suspended license. This isn't a minor traffic dispute anymore. The prosecutor opens by confirming that all the discovery Sigsby had been fighting for across multiple hearings, the body cam footage, everything, has finally been handed over on a flash drive right there in court. Proof of service filed, done. And the injured officer who had been blocking the case from moving forward, he's recovered and ready to testify. So for the first time in a while, this case actually looks like it's about to move. But Sigsby had other plans.
Mr. Sigsby?
Well, I'm going to need more time. Because I'm going to need time for this FOIA. To the Treasury of the United States, I request you for your W-9 and the court's EIN number, according to 26 U.S.C. 6903. And I feel I need to submit to the IRS a 3949A form on what's happening here. So I'm going to need to see a copy of your W-9. Can you say that on the record, please?
I will. I'm waiting for you to finish.
Thank you. That is elegant. Thank you kindly. And, I'm looking for a dismissal for this frivolous cause under 12B of the Federal Rules of Civil Procedures. All of them, all 7, are being violated right here on its face. So I'm going to need to request your W-9 and the court's EIN number. This is a taxable event. And I need to submit a 3949 to the IRS. I need time to send to a FOIA to the Treasury of the United States under 26 U.S.C. 6903 for the record, to be reserved on the record to correct the record.
So just when the case looks like it's finally moving forward, Sigsby completely derails it. He starts demanding the judge's personal W-9 form and the court's EIN number, claiming this is a taxable event and threatening to file a 3949A form with the IRS against the court itself. Then he pivots to requesting a full dismissal under Rule 12B of the Federal Rules of Civil Procedure, all 7 grounds, saying they're being violated right there on the record. Here's the thing though, Federal Civil Procedure rules don't even apply in a Michigan state court hearing. The judge knows it, the prosecutor knows it, and honestly, deep down, you'd think Sigsby would know it too. This is a pattern with sovereign citizens. Throw out enough legal-sounding language and hope something sticks. Nothing stuck. But Sigsby wasn't even close to done yet.
So here is what I am looking at in regards to a date. Mr. Sigsby, if I were to put this in January as opposed to December, would that make you happier?
It is fine with me, even though I am objection under special restricted appearance that there has been substantive due process violations across the Constitution and the laws of the United States on its face, including the 5th Amendment. My private property was taken without just compensation. The due process of there was never an indictment. This is a probable cause conference, and that's not suffices to satisfy constitutional substantive due processes that have been violated. And in the 11th Amendment, foreign citizens cannot invoke the judicial system of the United States. And once again, I can read off every way that you guys are foreign right here, easy enough. We have so we're looking at under 4J, Federal Rules of Civil Procedures, all courts, jurisdictions, and immunities fall under foreign state, 22 U.S.C. 92, 12 through 13, foreign relationships. Once an oath is required, it takes an oath of office to be required. 11th Amendment, foreign citizens are not cannot invoke the judicial powers of the state. That's 28 U.S.C. 3002-15A. The definition of the United States means a federal corporation. Foreign Sovereignty Immunity Act of 1976, 1605 through 1608. The government is liable for violating sovereign people's rights. And again, under Trinity versus Pegularo, anything that the prosecutor says and puts on the record is to be struck. Attorneys cannot give testimony or be a witness in a court case, and I do believe that has happened here too. So we have mass violations of the Constitution and the laws of the United States. And I'm going to need to see your foreign agent registration supplements and your filings with the Attorney General of the United States. I gave you a judicial notice, and nobody, not the clerk, not the judge, not the prosecutor, not the false impersonating prosecutor, has showed me a shred of anything. This is false impersonation of a government actor under 18 U.S.C. 912.
After Sigsby finishes his string of statutes and accusations, the judge doesn't flinch. She's clearly heard all of this before, multiple times, and she addresses every single point without raising her voice once. The W-9 request, denied. The dismissal, denied. The indictment argument, she walks him through exactly how Michigan's court process works. Warrant, complaint, arraignment, probable cause conference, preliminary exam, then trial. No indictments. That's just not how this state operates. She then issues a firm warning that lands harder than anything else in this hearing. When they return for the preliminary exam, she will not be entertaining any repeat of today's arguments. New issues only. Everything else is closed. That kind of calm, clear authority is hard to argue with. And the prosecutor didn't even need to say much. The judge handled it completely on her own.
Okay. The other issues that Mr. Sigsby brought up earlier, he's brought up on a couple different occasions. That's why I didn't really give you a chance to speak, Attorney Wallace. I apologize, but I believe I made rulings on those things before as well. Was there anything you wanted to say in response to what you just said?
No, Your Honor. I think that this has been discussed on the record multiple times. I think every time that we've been on the record in this case, I think the people's position has been made clear on this.
All right, thank you. And so I will say one more time, there have been no due process violations in this case that I have seen or that have come to my attention. There is no requirement for an indictment in this case. That's not how this process works in the state of Michigan. We don't do indictments. They do a warrant and complaint that is reviewed by the judge and then signed by a judge, and then it goes to the arraignment phase, and then it goes to the probable cause phase, and then it goes to the exam phase, and then it goes to the trial phase in circuit court if it gets past the preliminary examination. But we do need to have that preliminary examination. We are going to have that preliminary examination in January. When we get to the preliminary examination date, I will, the request for the other documentation is denied as well. Again, completely irrelevant to this case, and I'm not going to entertain those type of requests. And I do want to tell you, Mr. Sigsby, when we come back for the exam date, I am not going to entertain a restatement of the arguments that were made today. So if you want to make a new argument about new issues, I'll allow you to do that, but we're not going to go over these things again. We're not going to talk about EIN numbers and all this other stuff that you talked about. We're not going to do that, just like we're not going to go over this stuff because I have already addressed the other motions that were filed. So we're not rehashing things. We simply do not have the time to do that. We need to get this exam done. So I am looking at, I believe, January. Yeah. Okay, 20th? Yeah. I'm not duty for church conference. Oh, in the morning. Forgot about that. How would everyone feel about January 20th at 1:00 p.m.?
I'm objecting to any kind of court date, obviously.
I'll note your objection.
I know you will.
Free
I know
on
you will.
January 20th at 1:00?
Elegant would work. Yeah, can I get that in writing?
Yes.
That works for the people.
Okay, so we will set this for preliminary examination, and we will get you written notice today before you leave, Mr. Sigsby. January 20th, 2026, if you can believe it, at 1:00 p.m. All right?
Preliminary exam.
Preliminary examination, so make sure to bring documentation witnesses. That's the time when I'm going to hear those things to establish whether or not there is probable cause to believe that a crime exists or a crime has been committed. A crime has been committed by you, Mr. Sigsby, and has been committed in this venue being Genesee County. And if probable cause is established, then the matter will move on to your actual trial in the circuit court if probable cause is established.
Thank you, Your Honor.
Good? Okay, thank you, everybody.
Robert Sigsby walked in with a stack of legal-sounding arguments and walked out with a January court date he objected to, and a judge who's done entertaining the delay tactics. 3 serious charges, 1 calm judge, and 0 ground gained. I'm going with the judge on this one. She stayed patient, stayed fair, and never once lost control of her courtroom. Do you think Sigsby has a real defense, or is this just delay after delay? Let us know in the comments. That's a wrap on another epic case, and honestly, I have so many more where that came from. Drop a comment and tell me what you thought, and make sure you're subscribed to Court with Mia so you never miss the next one. See you there.